Hi, I'm Jacob Murad, president of KPA Lawyers. In this video series, we were looking to answer the question, why do lawsuits take so long in Ontario? As we saw, lawsuits take anywhere between 2 to 5 years, and the whole time you are paying lawyers. The legal fees can get up to $50,000, even $100,000 in certain situations. So how can that be? It just doesn't make any sense. And if we all know that that's a problem, why hasn't it been changed? So if you've watched the first couple of videos, we had a video on pleadings, discovery, and pretrial and trial. And you'll notice there's a common theme that at every stage something takes longer, and it's because of this idea of the opportunity to respond to something. Let me explain that a little bit more. We live in a democracy, for better or for worse. In this democracy, there's something called the rule of law, which means that if you're going to accuse somebody of something, they need an opportunity to defend themselves. They are presumed innocent unless proven guilty in the criminal context. In the civil context, you're presumed not liable unless there is a verdict that says you were liable. What does that mean? That means if someone sues you for a breach of contract, the person that is doing the suing has to prove that there was a contract, it was breached, and you've suffered for it. The other side, after they've seen the evidence in front of him, the other party has an opportunity to provide their own evidence. Maybe there wasn't a contract. Maybe there was a contract, but they didn't breach it, and so forth. This idea makes sense in theory, and it's kind of good. Hey, you don't want to get someone in trouble or make someone liable to pay millions of dollars without them having an opportunity to defend themselves. So that makes sense in theory. But in practice, look what happens. We looked at the pleading stage, where you start the pleadings by bringing a statement of claim where you outline everything that you're suing the other person for. And then there's a period of time for that person to respond by filing a defense. The other side files a defense, but then maybe does a counterclaim. I didn't breach the contract, and if anything, you breached the contract. Now the other side has an opportunity to respond. What also happens is you can bring in another party. It wasn't my fault, it was this person, and they're brought into the lawsuit. They need an opportunity to respond. Everybody needs an opportunity to respond. Also, we talked about process servers and how you have to serve people properly. Why? Because when you serve people properly, they are given proper notice to respond. If you didn't serve someone properly, then it's not fair because they didn't have an opportunity to respond. So I file a lawsuit. Maybe the person didn't get the lawsuit. So hold on a second. I didn't get the lawsuit. They didn't serve me properly. And what ends up happening is you get into the motions. We talked about motions in the last video. Motions are mini trials. Hey, I started a lawsuit. They didn't answer. I want to bring a motion to automatically win. The other side says, hold on a second. I'm bringing a motion because they didn't serve me properly. I was out of the country and they knew they were out of the country. And they have a mini trial on this subject. By the time it's heard, it could be several months down the road. Remember, the lawsuit itself about whether or not there was a contract breach, we're not even talking about that. Right now, we're only talking about whether or not someone was served properly and had enough time to respond. So that's where we are. Every single time you go into another stage in the litigation process, by giving the other side, by giving each party a fair opportunity to respond within a reasonable amount of time, you add more time to the trial. And now that's the first part. And the insidious part of this is think about what happens to the court system. There's a finite amount of adjudicators, judges, and so forth that rule on all of these subjects, whether it's a motion or a trial. And when the courts are filled up with a whole bunch of motions about whether or not someone was served properly, whether someone gave their documents on time, whether they gave the right documents, or whether a document is privileged or not, by the time you have all the adjudicators talking about all of those subjects, the courts in each region get full of, I'll call it, garbage, for lack of a better word. We're not talking about the merits of your case or trial or anything. We're just talking about all of these little opportunity to respond motions. And then what happens is the courts are full and there's no judge to hear your case. So you need to schedule a time to speak. And some judges, they're only hearing cases a year in advance, 2 years in advance. Now, to the credit of the Law Society, of the different regions, they are trying to they're trying to fix the issue and provide better access to justice. But it's very difficult because there's only a finite amount of judges and there's an infinite amount of claims and an even further infinite amount of motions and different disputes within each trial before you even get to trial. And that's why it takes so long to get to trial. And the whole time you are paying a lawyer. Now that we've talked about why it takes so long, then the next logical question is, well, what can I do? In my view, there's really only two things you can do. The first is don't start a lawsuit. Instead, go with an alternative dispute resolution process, arbitration, mediation, some other form of business solution so that you don't have to go into this black hole of a legal process that is in Ontario until, of course, there's some sort of legal reform. Try some other form of resolution to your problem. And if you're wondering a little bit more about that, I have a video on alternative dispute resolution mechanisms, which you can click on. What happens if you really just want to start a lawsuit? Maybe those other dispute resolution mechanisms are not appropriate. Or what happens if you're sued and the other side does not want to settle? Well, then the answer to your question is, and I hate to say it, cutting your losses and moving on. So if you're the person that's doing the suing, the answer is to actually cut your losses and move on. Let's say, for example, you were fired from employment and you felt you were constructively dismissed. This might be an unpopular opinion, but the real answer to your question is to move on. Find another job. If there was a breach of contract, move on. Find another business or grow your business in order to find a new person who you'd rather do business with that won't breach their contract and will do what they say. Grow your business. What if you're being sued and you can't just move on? I'll point you to my other video, which is how to win any lawsuit. Grow your business, grow your life socially. Because then by the time it takes as you can see, by the time it takes for the lawsuit to reach its resolution or you get to a point of settlement, you will be making enough money growing your business in order to pay for that resolution. And again, I advise you to click on that video so you can learn a little bit more on how to win any lawsuit. You use this to your advantage in order to grow your business and thus pay any resolution, whether you win or lose. The reason for this is that lawsuits take way too long, and unless there is some significant reform in the process, it will not help you. So, if you like these videos, please feel free to click like and subscribe. Bye for now.